And typically we don't require the investigator to leave. I'm not sure your position on
Oh,
the investigator.
yes, so she's more than welcome to stay if you would like to come up again for, and I'm not getting testimony for the rest of the witnesses.
Oh, sure. Is it okay if my colleague stays
Oh,
as well?
yes, of course.
Okay.
I can get that way. You don't have to speak here.
You can call the next witness when you get a chance.
Thank you, Your Honor. The people will call John Jewell.
Please.
Now, Mr. Jewell stepped out to use the restroom, so I'm actually going to be calling Ms. Jackson to stand. You can go. You can move your bag if you'd like. You don't have to, whatever. And just stay standing so she can.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can have a seat. Okay, and have you testified in court before?
Yes.
Okay, please state your first and last name and spell both.
Lisa Jackson, LISA JACKSON.
You can proceed, counsel.
Thank you, Your Honor. Still barely good morning, Ms. Jackson. How are you doing today? Are you currently employed?
No.
Were you formerly employed by the local 48?
Yes.
And what was your role at the local 48? Or excuse me, I said 48, 488.
Central Michigan Area Local number 300. I was president.
You're president. And what types of duties did you have in that role?
Calling meetings to order, establishing committees for each of our areas within the union, approving, coding currently for different employees to do things, like go to an office or anything special that's going on. Signing checks.
Okay. And what? How long did you have that role?
I took over. I was vice president. It must have been 2016, and I took over for our previous president, and then ran unopposed. So it must be about 5.5 years.
Okay, so 5.5 years, starting in about 2016.
Yeah.
Okay.
Yeah. 15. Because I left in 2020 was the end.
Okay, so you actually starting around 2015.
Yeah, because the terms are 3 years. So 18, 19, 20, 17, 16. Yeah, maybe end of 15. 16.
Okay. In the course of that role, did you have occasion to meet Mr. John Greathouse?
Yes.
And did you see his face?
Yes.
Is he present in the courtroom today?
Yes.
Can you describe where he's located in an article of his clothing?
He is located at the table, the opposite end of the table that you were standing at, and he has on a navy blue suit.
Thank you. I'll let the record reflect that Ms. Jackson has identified the defendant.
Any objections?
No objection.
So noted.
So what was Mr. Greathouse's role when you were president?
He was my editor for our newspaper, and he also did other, did the legislative director, I believe. He was legislative director. He was on several committees. Um, I know he was on the Human Relations Committee. Not sure if he was on the Constitution Committee, but I think he may have been on the Constitution Committee.
Okay, so he was doing quite a bit of different union
Yes.
duties.
Yes.
Would being, oh, excuse me, let me rephrase. Do you know about how long Mr. Greathouse has been with the union?
Probably the entire time he was employed.
Do you know about how long that was?
Over 25 years. Sure. You may have 30 years.
Based
A
on,
long time.
yeah, based on your experiences working in the union, would someone who had been in the union for that amount of time, would they have had any sort of trainings about how to enter in their time? The time, like the wages worked?
Yeah. Yeah. We go over that with everybody, like our new stewards and stuff like that, because they really don't know how to do it. So yeah, we really know.
And if policies were changed, would people be informed of those policies?
Yes and no. And sometimes I would say yes. Okay, but the reason I say no, sometimes things happen and everybody doesn't know about it. I had somebody tell me, I never knew, we had a union picnic and, it's like, it's in the paper, we advertise and we put this big thing up on the board, so,
Okay, so like someone would be informed of it, but they might not necessarily, you can't control what they're
right,
saying.
right.
Is it standard practice under the union's policy for people to submit lost hours based on a personal log?
What do you mean?
So if someone was recording their the hours that they were working as like lost time, is that standard for people to do?
Well, they would put their lost time on a 3971, that would be approved by management, and then they would fill out a voucher for the union and put their time on the voucher. I don't know what you mean by law, but the voucher.
Okay.
For payment, for
Work done for the union.
Right.
And if they were doing that, would they also be able to receive pay from the Postal Service for that time?
No, you either work for the union, or you don't, not for the same time, it's either for.
Okay. Were you aware of any instances, or if you had taken part in any instances of advising Mr. Greathouse on how he should enter in his time?
Well, I didn't advise him, but I know that John was doing quite a bit of outside stuff for our union. He got together the whole anniversary and got congressman and to come, and they did a big speech and down by the little postal store that we have. I know he does a lot of outside stuff. And I know that it's difficult to do with the hours that he works. John works the night hours, which I used to work. So on those hours, it's hard to do stuff. So he would have to convert over to daytime hours in order to get stuff done. And then by the time he goes back to work, he'd have to flip back over to work. So it gets a little difficult, but he does a lot for the union. Talking to congressmen, there were a lot of politicians that he found out. I didn't even know about it. They were having like a little talking and eating little things, and he told me about that, and he wanted to go, and I said yes, and he was actually out there on the floor talking to people about voting by mail. How that would be important, trying to keep business in the post office and talking to these people about how it would work. So,
as excuse me, as president, is it your role to authorize hours when people are requesting them, or they're like using different types of time, or is that your part of your role?
Yes. Some people get it automatically in the Constitution with their title, like he would get so much lost time or being editor. I would automatically get so much, it just depends, but anything outside of that.
And so in that, like, for being the editor, that would be those like 16 hours for when is it the Pacer is
Yeah.
published?
Yeah.
Were you ever made aware that Mr. Greathouse been filing false claims?
No. Well, I say no because I didn't know in advance, but when the people from the Department of Labor called and wanted to interview them, that's when I found out that some of the claims are false.
Would you have authorized those claims had you known?
That they were false?
Yeah.
No. You can't work and get code 84, which are union time at the same time.
Oh, I guess.
Your Honor, sorry to interrupt, Ms. Petrosky, but I would ask for Ms. Sellers to be sequestered at this time since she's acting as co-counsel and gesturing to the witness.
She is the investigator.
Right.
We don't typically sequester the investigator. They typically sit next to prosecution to help them in question. It's difficult. I just had one, right, Detective McGonigal, she was the investigator. So they would know because she has the intimate knowledge what this prosecutor needs to ask.
Well,
I don't know why she would be gesturing the witness though, if that happened.
She was just shaking. I don't know if she was doing intention. I'm not used to that. No. But she was just nodding her head
Okay, well,
affirmatively when the witness was testifying. But I don't know if you meant to do it. But.
No, no, I didn't. But I mean, I'm happy to step out, if there's anything.
Well, I mean,
that's up to Ms. Petrosky if she feels comfortable with not having the investigator there. This is a specialized area of law, that's for sure. And so this is not something that's commonly come to the court. I'm learning stuff as I'm sitting here. I can only imagine Ms. Petrosky is learning stuff and probably may not know all the questions she should be asking. Or, listen, every time you all throw out these code numbers, makes my head spin.
Yeah.
So-
Last time is a difficult area, so I recognize, and I apologize. I'm not motioning to her. It's just an affirmation of what she's saying. But yeah, I
didn't even know.
You've been looking right at me, so.
It's my personal, I apologize, but yeah, I'm happy to step out, whatever makes everyone more comfortable.
I'm not ordering her to be sequestered because I recognize she's here to assist in the investigation and prosecution. So to the extent that there's any appropriate gesturing, I don't know that was the case. I think she probably was nodding her head. I didn't see it, but
I nod when I listen to
I think
it.
the prosecutor nodded her head too.
Yeah. I nod quite a bit. I want to try.
Thank you. You can proceed.
Thank you. So I want to talk a little bit more about the keeping of a personal log of hours. So if someone is doing union business on their own time, keeping track of it. Yes, and then later submitting that, that time, are they permitted to be paid overtime for that?
Overtime?
Or, excuse me, union time for that?
It depends, yes. Usually, yes. Especially with people that work the nighttime shift, it's hard for them to do day work and night work. And so at one point, I did talk to John and he said that he had some hours that he was going to put in for because he did union work, let's say like 4 hours, but then he went on to work that night because it was too hard to flip over. And he did that on several occasions. And he did say he was keeping the log and going to be putting in for that. I didn't have a problem with that until we were at a union meeting and somebody talked about people banking hours. And at that point, you weren't supposed to be banking any more hours. You either had to use the code 84 of the day you were working for the union or the day adjacent with the night people, because it's hard. So your whole day before you have to come that day or the day adjacent to the day that you were taking off and not accumulate a bunch of hours.
So to accumulate our, oh, I'm sorry, I cut you off. What were you saying?
So the time that he had already asked me for, yes, he was approved for that. But after that, after it came after the meeting and he said you couldn't do it anymore, then it was supposed to stop.
The, trying to figure out how to ask the questions here. Like I said, learning a lot of stuff. So, with the, it would be a violation of the union's policy then to claim those accumulated hours. If they were outside of like the, outside of like the workday, correct?
Outside of that meeting
Yeah.
that we had.
Okay.
Yeah.
Do you know whether he continued to accumulate and submit those hours after you spoke to him about it?
Well, I didn't speak to him personally about it. It was like I said, it was at a union meeting.
Oh,
We were all there. I think it was in attendance with John Hunts, but all in the meetings, but no, I didn't speak to him about it.
So I want to ask you about a specific incident where Mr. Greathouse had asked you about accruing time to attend the Postal Press Association. Did you speak with him about that?
Yes.
Could you kind of, I guess, what was he asking you about?
Oh, he said that he had used quite a bit of hours doing work for the union. And he wanted to, he's not gonna submit those hours now. He wanted to wait and submit those hours when he attended the Postal Press Association, because at that point, he would either have to use his own annual leave or vacation time or LWOP. And days of LWOP is a lot of money. So if he's doing stuff working for the union, he would wait and then submit it for that particular conference.
And
I said yes.
you said that he could do that?
I said that he could do that. That was before I found out that banking hours were a no-no and we couldn't do it. Came up at a meeting. I'm not sure even what meeting it came out. So I'm not sure what meeting and who brought it up, but it was later. And the reason I say that because later at a different meeting, somebody said, "Oh, we talked about that at a previous meeting, and they're not supposed to be banking hours anymore." And I said, "Well, I wasn't aware of that. I told him that he could do it, so he should be paid, because if I gave him the permission to do that, then he should get paid for that." And the new president refused.
Do you remember what year about that was when you had that conversation with them?
It had to have been 2019, because I retired in 2020. I retired right after COVID. Well, yeah. So I wasn't at the post office much at all in 2020.
So if he was making those fraudulent filings after that date in 2020, that would have been after that meeting that he would have known, or that he would have learned.
2019, right. Yeah, because all of our meetings in 2020 were done via Zoom.
So if Mr. Greathouse was keeping track of his hours for, as like lost wages for union time. If he had also been compensated for that time, under either annual leave, or if he had already been compensated for working for that time, would he also then be able to be reimbursed for that time under lost wages?
If you took annual leave for that time and then came back. No, you can't use annual leave and union time, quarterly for the same.
Okay, so if there were two instances where both the same date said that he had gotten the annual leave and he had also gotten the lost wages, that would be a violation of the policy.
Yes, no.
No further questions.
Cross-examination.
Yeah. Yeah, it's nice to put a name with a face, you know, these names. Now, you worked with Mr. Grayhouse for a number of years, correct?
No, yes,
And would you agree that he's a valued employee and a man of integrity?
absolutely. He was my right hand. Actually, I depended on John more than my vice president. She couldn't do a lot of stuff, and John was always willing to help and bring his family in to help. Because to adopt families for to the Salvation Army, and John and his whole family come in and help wrap presents and do shopping, because there's a certain things that you have to get for each child, and we had to make sure we had everything, and so you know it's been great. Union picnics, we did employee appreciation days. John was always there. Helping me. I count on him.
And how long would you say you depended on him in that regard?
Oh, well, ever since I was president in those 5.5 years, and even before that, we sat on several committees together.
Now, you also stated something very important and thank you for acknowledging that by him working third shift, it can get confusing as far as the dates when you're applying lost time. Is that correct?
That is correct.
Okay. Now, by him using a personal log, well, I'll just ask it differently. I don't want to confuse you. Because again, this is convoluted, so I want to make sure we have it very clear for the record. Since he does day and night work, you stated that he is allowed overtime at times?
Not overtime. Overtime is paid at time and a half. Union doesn't pay overtime.
Oh, okay. I'm sorry, not overtime, but so he would have some days where he would have to split his time. That's what you were saying, because he had to do things that were outside of his normal work schedule.
Yeah, and can I explain a little bit?
Yes, ma'am.
Sometimes employees, like on night shift, who are we have it called the overtime desirable, so they want to work overtime through the post office where they get paid time and a half. And if they're not there, the union won't pay them overtime. They have to miss that overtime. So sometimes employees do come to the union meeting today, go into work overtime, and then the next day they take the time.
And that's allowed?
That is allowed.
Okay. So that means that, in your opinion, I guess from being an employee for almost as long as Mr. Grayhouse, that his pay could vary from each paycheck due to him working additional hours or overtime or various other factors.
His pay, yeah.
So it wouldn't be the same every 2 weeks. You wouldn't get the same amount of pay.
No.
Okay. Now, you even approved hours for him that he had banked, correct?
I did initially, correct.
And you did that until 2019, is that
I
correct?
think it was 2019
Okay.
when the big dispute came up about it.
So would you agree
Because
until?
quite honestly, I didn't even remember that meeting where they said you couldn't bank hours. But I think somebody pulled the minutes for me and it was.
And you were the president at that time,
Yes.
correct?
Yeah, you know, when you get in the habit of doing things and then you have to change and do something else, yeah.
Absolutely. So being that those hours were approved, did you ever have any reason to question Mr. Grayhouse's integrity and that he
No.
wasn't being honest?
No, And you know, when we pay out leave, you know, the vouchers go to the treasurer makes up the check, the treasurer signs and give it to me, I kind of check over it, you know, look over and, you know, if I remember, I mean, then I sign the check. But we don't go back and check through the post office if they were actually there or not there. We don't pull, you know, it's on a timesheet from work. We trust our people, and we have to trust their integrity, that this is the time that they're putting in for, they were gone. So we don't pull that part of it. We never have. So if there was some discrepancy, I trust the people who are putting in the time. Oh, you said you would do this and then you.
Now, I guess my last question to you, Ms. Jackson, is that being that you work so closely with Mr. Grayhouse in the union as well as at the Postal Service, would you have ever had a reason to go back and question anything you did based on any previous actions?
Absolutely not.
Thank you, Ms. Jackson.
No further questions, Your Honor.
Thank you, Ms. Jackson. I'm gonna advise you that there's a sequestration order, so that means you're not to discuss any portions of your testimony with any other witnesses, okay?
Am I allowed to leave?
You are allowed to, you're allowed to leave.
All good to go.
Thank you.
Now the people will call John Jewell.
Kleenex.
Testimony in court before?
No.
Okay, so there's a couple of rules. There's a microphone that's in front of you and the lady behind you, she's my court recorder. She has to take down everything being stated here today. We got the fan going because it's warm in here, and then that could block sound sometimes. So if you can keep your voice up, that'd be helpful.
Okay.
You're doing excellent with giving verbal responses because we can't rely on head nods and shakes or mm-hms and uh-huhs because we can't write that into the record, okay? If you forget, we'll ask you if it's a yes or no.
Okay.
If either attorney says objection, you will stop speaking immediately. I'll make a ruling on their objection and then I'll tell you if you can give us that answer or not, okay?
Yep.
State your first and last name and spell both.
John, John, Jewel, Jewel.
You can proceed, counsel.
Thank you, Your Honor. Good afternoon, Mr. Jewell. How are you doing?
Very well.
Where do you work?
The Collins Road Post Office.
And are you a member of the union for that post office?
Yes, it is.
And is that the local 488?
Yes, it is.
Do you, excuse me, do you know where the headquarters for the local 488 are located?
Yeah.
Do you know the address?
I'm not sure the address, the post office box, 21154.
Is the post office box right by where it's located?
No,
Oh, it's different. Okay.
Yeah.
If I said that it was 419 South Washington Square in Lansing, would that sound familiar?
yes,
Correct?
that's the AFL CIO building.
Okay.
Yeah.
And so is that in Lansing?
Yes,
Ingham County,
yes.
state of Michigan?
Yeah.
So what is your role with the union?
Right now, I'm the chief steward in the Lansing facility.
What does the chief steward do?
Basically, I am there to advise the other stewards and answer questions they have about the contract I also process grievances, and I'm the primary person who handles that bills.
How long have you been a chief steward?
Chief steward, probably about 10 years.
And were you a steward before that?
I started off as a steward. I became the installation director for the Lansing in 1995, and I just stepped down from that role January 1st of this year.
In the course of that role, did you ever meet Mr. John Greathouse?
Yes.
And how did you two meet or know John?
I actually met John when I first came down to Lansing. I first worked in East Lansing for 17 years. Took over our mail processing operation. I met John on the roofing floor. He lived in 1992. Then he became active in the union approximately, I'm guessing, the mid 2000s. And John was was a steward on our 2 or 3 at the time.
You work with him quite closely. And so would he would someone in John's role, would they have received information about the union's policy on pay? And their policy on lost wages?
Yes.
The sort of annual leave versus leave without pay?
Yes.
Did you ever have conversations with John about any of those pay policies?
No, the pay end of it isn't something that I dealt with. That was basically contract enforcement and the positions I had, but we all filled out the same vouchers for pay.
So can you explain to me how the voucher system works?
Sure. Anytime you're performing work for the union, with the exception of grievance process, that time is paid for by the union, not by the employer. Anything that has to do with processing grievance is paid for by the employer. Basically, if you spend time performing union activities, then what you do is fill out a voucher, either for expenses, or if you're taking time off from work to perform union duties. What you do is fill out, it's called a form 3971. And basically it's the same slip that you fill out for any leave from the post office. And what you do is mark it as code 84. That shows it's unpaid leave specifically for performing union activities. And then what you would be reimbursed by the union for the time you lost from work performing those things.
And so someone could not fill out a form 84 and then or no, excuse me. So someone would fill out a form 84 saying that they are taking this time off from the post office, and then they would also be filling out that voucher to
Right.
then get those hours.
What you would basically do is attach the approved 3971 stating you requested code 84 for that time period. You attach that to your voucher.
And so if you submitted a voucher for payment without that approval, would that time still be able to be approved or I guess compensated?
I would certainly assume that the treasurer would ask you for a copy of your 3971. Yeah. Because that's supposed to accompany whatever voucher you have.
So were you aware of any reimbursements that Mr. Greathouse received for lost time while also being compensated by the Postal Service? Were you aware of any of those?
The only time that I became aware of it was when the investigator from the Department of Labor who interviewed me. I'm unclear on the date, but I believe it was the August before last. She showed me some vouchers. There was one particular week where I believe that it showed that John had gotten paid annually for a week that he also was reimbursed by the government.
And is that an approved practice?
No, it's my understanding, and it's been a practice of the local that normally you only get lost time or unpaid leave.
Is it standard practice for someone to keep a personal log of lost time hours and use those to be compensated?
It would certainly not be standard practice. There's language in the Constitution where if the president has the authority to authorize a deviation from the normal filing, but that would certainly not be standard practice for a local, no. That would be something that would have had to have been approved by the president. And people keep logs for their own personal use. Submit that normally with a voucher.
No further questions.
Cross-exam.
Your Honor. Still.
Hi.
How long have you worked with Mr. Greathouse?
Mr. Greathouse, like I said, I first met John in 1992
Was that the post office?
at the post office. Yes.
And he's also served with you on the executive board of the union, correct?
Correct.
So during that time, have you ever had any reason to question his integrity?
No.
What about his dedication as a valued employee?
No, he has done a very effective job with our newsletter. He's probably been the best person we had doing that. He's also very capable for all the time.
I know you stated that you don't deal with payroll and
No.
those types of issues. Now, is your understanding of the union policy that if there is time that's in question, or I'm sorry, let me just restate, I'll walk that back. Is it your understanding of the policy that the president would have to approve lost time vouchers?
The president would sign off on any payment that would take place from it. All our checks are duly countersigned by either the president's not there, the vice president, and the treasurer. But it would be, the treasurer would be the primary person who would be getting the vouchers. We fill out vouchers, we leave them in the holdout for the union treasurer. And if the treasurer had any kind of questions, then that would be the person who would likely contact the employee to find out, what's up with this.
Now, if there's any deviation from the policy that would have to be approved by the president?
Yes.
Okay.
Absolutely.
In your time since you worked with Mr. Greathouse since 1992,
Right.
which is over 30 years now, have you known him to partake in any fraudulent activity or do anything that would have him reprimanded at the job?
Not that I know of, no.
Thank you, Mr. Joe. No further questions.
Can you read her?
Just real quick. So when the president is approving the lost, or making the approval for the payment of the lost wages, what would their approval, what would that be based on?
I'm not part of the process, but I would imagine it would be based on the documents that were submitted along with the voucher.
No further questions.
Thank you. There's a sequestration order, so you're not to discuss any portions of your testimony with any other witness, okay?
Yep, that's fine.
Okay, now it looks like you have another witness that just walked back in.
Oh, yeah.
You can be excused, and to the extent that you need that done too, you might as well get it done now.
Okay, great. That sounds good.
Mayor, did you drive over 50 miles?
No, 22.
She knows. How much is there over 50 miles?
No, it's 60.
I'm going to disappear for a while. Thank you.
Thank you.
Any additional witnesses?
No, Your Honor.
Okay, is the defense calling witnesses today?
No, Your Honor.
We can proceed to argument.
Thank you. Today we heard testimony from Ms. Lisa Jackson and from Mr. John Jewell, both members of the 488 Postal Union or Postal Services Union here in Lansing. Mr. Jewell testified that it confirmed that the base of operations for the local 488 was in fact Lansing, in the city of Lansing, Ingham County, state of Michigan. We also heard testimony from Ms. Kimberly Sellers as an investigator for the Department of Labor. The elements that I am required to prove to a probable cause standard was one, that defendant used a pretense. Here, the pretense is that he was not being compensated for the time that he took under annual leave, and then was actually, when in actuality, he was being compensated via annual leave and also by the lost wage policy of the union, thus kind of double dipping in essentially, in effect. I next have to prove to a probable cause standard that the pretense was false at the time that he used it. Mr. Greathouse had been a member of the union for a minimum of 20 years. There's some dispute about exactly how long, but he has been a member of the union and an employee of the Postal Service for about 30 years. He's, Ms. Jackson testified that people are informed of the policies, and that and if there are issues, that they will speak with people who potentially are having some issues with their wage policies. And that Mr. Greathouse was present at the meeting where a change in the policy of the pay was discussed and made clear to the members of the union. From that testimony, I think to a probable cause standard, it is clear that the defendant did know that the pretense of trying to be compensated for both wages was false, that he knew that that was not an accurate representation of how his time was actually being spent. And then at the time that they used pretense, the defendant intended to defraud or cheat someone. Again, without hearing from Mr. Greathouse directly, we don't always know exactly what was going through his mind, but based on the fact that he was receiving these double wages, he would have had access to his pay stubs, or if he perhaps didn't access his pay stubs or his hours, that a reasonable person should or would have knowledge of that. So I think it's perfectly reasonable that to expect that he did in fact intend to defraud or cheat the union by going through and basically utilizing these strategies to get double pay. The policy for approving these vouchers or approving for this lost time is handled by the president. So that person in this instance would have been Miss Lisa Jackson, and she directly relied on the way that the vouchers were presented, the documentation that Mr. Greathouse presented to her, that he wasn't, in fact, that he wasn't engaging in this fraud. She believed him, and that's why she approved the payment for these wages. And she explicitly said that she, if she had knowledge that he was in fact taking part in these strategies, she would not have approved those things. So that satisfies the element of another person relying on the defendant's pretense. And then by relying on this pretense, the person, or in this case, the entity of the union, suffered the loss of something of value, and that value, in this case, was $1,000 or more, but less than $20,000, based off of the investigation done by Ms. Sellers in her comparison of the times worked by the times that were Mr. Greathouse was compensated for annual leave versus the times that he was compensated via the lost wage system with the union, that in total, that amounted to at least $7,406.87 over this time span from February of 2016 to May of 2020. So within that date range, the union lost these $7,406.87, lost that because they were basically compensating Mr. Greathouse for work that he either didn't do or compensating him doubly. So to a probable cause standard, these elements have been met, and the people would ask this court to bind over as charged.
Thank you, Your Honor. Your Honor, the defense recognizes that the burden is fairly low in this case. We have to prove that it's more likely, the state will have to prove it's more likely than not that the crime of false pretenses occurred by Mr. Greathouse. As Ms. Petrosky stated, you do need to have a pretense as the first element based on Michigan compiled laws and the jury instructions. Now, a pretense is defined as a statement or writing that is false, and that pretense will be given to a party, and that party would rely on that pretense due to its intended nature to defraud or cheat. Now, we've heard testimony that from the sellers that there was no writing because they have been destroyed. If they ever existed, we don't know. Secondly, we also heard from the sellers that she did not even ask anyone in management that Mr. Greathouse could have spoken to request the annual leave. So therefore, there was no pretense. Secondly, we've heard from Ms. Lisa Jackson, who testified that it's difficult to keep track of hours due to Mr. Greathouse's work hours. He does work third shift, and he does a lot of things outside of normal work hours. And maybe there was some oversight, but it will have to be intentionally done to defraud or cheat the system, a system that he's worked for 35 years. He's been married for 38 years. He's raised his children. He has grandchildren. I don't feel he will risk his integrity, his reputation, and his legacy at the post office, being that he is retiring soon. He would risk that for $7,400 when he's amassed over $2 million in his salary since he's worked there for 35 years. He takes care of his disabled wife. He's a man that volunteers. He spends time with children. He served our country. I just don't feel he will risk.
I don't know all those things. Those are not in facts and evidence.
Okay, maybe that's just, sorry, my passion for my client, Your Honor. And I know he has not been spoken today, but I just wanted to make you aware of those facts. And even Ms. Jackson spoke to his integrity. She spoke to the fact that he's been honest. She's dependent on him throughout her time as president. She also stated that she wasn't even aware of the policy. I mean, in 2019, she said that's when it was brought to her attention that she may have been approving time that she wasn't supposed to approve, and she didn't even realize that.
I thought that the policy issue, though, and I wanted to ask this even when Ms. Petrosky was talking, was about banking the hours or keeping the separate log. Not necessarily, I didn't get the understanding from anyone's testimony that there was ever a policy that allowed for an employee to get paid from the union and the Postal Service. I never got that understanding.
No, that's correct, Your Honor. There's not a way that you can get paid from both. I was just stating that there may have been some overlap due to the fact of how he has to log his hours because, and I feel, and that's why he used the personal log to try to keep track, But again, there's room for error, and Ms. Jackson also stated that she had no reason to question his integrity or his honesty. Even Mr. Jewell stated that, I mean, he doesn't handle payroll, but he had no reason to question the integrity. These people have worked with him for over 30 years. Mr. Cosper, who did not testify, is now the current union president. He changed the policy, but that was in 2021 after the time period of the investigation. So I'm not sure what happened since that date, but we didn't hear from Mr. Cosper. But also, he was allowed to do extra things outside of his normal work hours. So his pay would fluctuate every 2 weeks. Ms. Jackson also stated that is a guaranteed fact that he would be getting paid different amounts. And he has admitted to me that he doesn't check his pay stubs. I mean, I don't check them
We
either.
can't talk about that.
No, I understand.
I can
understand.
only consider evidence presented to me during testimony at the preliminary examination. What you're giving is argument about stuff that's not in evidence.
Well, I'm stating that because Ms. Sellers did, I know it wasn't speculation necessarily, but she did assume that a person would check their pay stub. So I'm just giving.
I get that,
Right.
but what you're now arguing is something that is not, it's something that was presented in evidence. So I can't take that into consideration just
Okay.
because you're arguing.
I can strike that statement, Your Honor. In summation, I just like to state that based on what we've heard today, there has not been a pretense that was used in the statement. No one has testified they heard a statement of him requesting annual leave. No one has testified that he presented a writing requesting annual leave. So therefore, with no pretense, we don't even get past the first element of false pretense, the statute of false pretenses in Michigan. So I do feel that based on the assessment and what we heard today, I would ask you to dismiss the case with prejudice. So Mr. Greathouse can continue his legacy as an employee of the Postal Service. Thank you, Your Honor.
Thank you. Additional argument?
Thank you, Your Honor. I just would state that the jury instruction on defining pretense, which is 23.9, it states that a pretense is a statement, writing, or any other device that is false. And I think the way that device is being used here, it's functionally a communication that is being conveyed by Mr. Greathouse. And I would say that the his not working on days that he was also being compensated for, that is a pretense. If he, but it basically, if he is presenting himself as having not been working, he's presenting himself as, I was not working for the Postal Service that day, therefore I am taking my lost wage pay. That is a pretense. Then the fact that he then received that annual pay for that, that is where the rest of the elements comes in. So I don't believe that it needs to be a literal statement or a literal piece of writing by Mr. Greathouse.
Okay, this is great, because if I had known that this case was going to involve this level of new information, I would have had lunch first. Nonetheless, today is the date set for preliminary examination, and for your information, Mr. Greathouse, to the point that your attorney argued at the beginning of his argument, was this is a low burden. So it's more than mere suspicion that a crime was committed. This is not a trial. The prosecution doesn't need to prove each element beyond a reasonable doubt. The court does take only into consideration the evidence and circumstances presented to the court today, and that would include testimony under oath and or if exhibits were submitted. And not to dispute that many of the things that your counsel can share about you personally isn't true or not. I just don't have it in evidence to consider it. And maybe that's evidence that would be appropriately addressed at the circuit court if this is a case that would make it to trial. But it's not something that's before me to consider. I'm looking at the elements, I'm looking at the testimony that's being provided and the evidence being provided, and seeing if there's more than mere suspicion that a crime or the crime that was alleged was committed, and more than mere suspicion that you created that crime. Then I can also weigh the people's likelihood of success at a trial. And so we had testimony today of various witnesses, and first being the investigator, Kimberly Sellers, indicating that she was investigating an issue involving some misappropriations of funds in the Lansing, Michigan, Ingham County area, making venue before this court appropriate. And that there was issues as it relates to some discrepancies that she reviewed, and she said she reviewed some union records to cross-reference so that she could see what was going on, and that she highlighted or noted that the person she identified in the courtroom today as the defendant, John Greathouse, would have been paid by the union and the postal service the same date. She says that there was annual leave for 14 days. On those days, he was also paid for union work. She discussed issues regarding a separate log being kept and why that could pose a concern and how that was addressed. It looks like there was some other people or employees, particularly Ms. Jackson, who may have been misconstrued about the use of a log, but then it sounds like at some point that was corrected. What the court gathered here today from the testimony of all the witnesses is, and each of them have said it almost to the T, even with the sequestration order, is that you can't get paid from the union and the postal service. That is the issue. Now the question is whether or not the defendant got paid and that he did some act that rose to the level of a pretense that was false to get payment from both. And so the court made questions herself about whether or not the defendant's supervisor could, unilaterally on their own accord, just go ahead and enter annual leave, even though the defendant may have put in for a request to be paid from the union. And the understanding is that is possible, but that there would be a request, or typically be a request made for annual leave to be used. Those records we don't have because they would have been destroyed due to a time limit. And so now the court needs to go through these elements and see if we have more than mere suspicion to meet those. So false pretenses, again, requires that the people prove at trial beyond a reasonable doubt, first, that the defendant, Mr. Greathouse, used a pretense. I think Ms. Petrowski clarified that the definition of a pretense doesn't just mean a statement, the use of a statement or writing. It says also, or any other device that is false and or that could mislead the person it is presented to. So in this particular case, the pretense would be any mechanism that was used to convey that you had been or not have been paid by annual leave when submitting for payment by the union. And so the court is satisfied that we have a pretense as it relates, at least to a probable cause standard in this particular case. Second, the people would need to prove beyond a reasonable doubt that the defendant knew that the pretense was false at the time he used it. Third, that at the time he used the pretense, the defendant intended to defraud or cheat someone. Fourth, that the other or another person relied on the defendant's pretense. Fifth, that by relying on the pretense, the person suffered the loss of something valuable. And sixth, that the amount of the loss had a fair market value that was at the time it was taken. In this case, we will go to section B, 1,000 or more, but less than 20,000, because the testimony was that the loss suffered was that the amount of 7,000 and some change. And so the court did hear testimony that I believe satisfies to a probable cause standard. Of course, that element 6 being the amount, the fair market value, was that which falls within the range in section B. As to whether or not that false pretense or that pretense was relied on by another person, well, we had testimony here from Ms. Jackson that would submit or approve payment based on receiving information that needed to be paid for union work, not understanding that he may have already put in requests for payment for annual leave. the element as to whether or not the defendant knew that the pretense was false at the time that he used it, I think is the lingering question, because it's likely that the defendant did not make any request for annual leave, and 14 times that the his supervisor or someone who was in control of his time leave just took it upon themselves to put in a request for annual leave. I guess that's possible, but it's also very possible that that's not what happened. And when you consider the amount of times this happens, because that has to, we have to look at this as a totality. And also we consider the fact that this is a 30+ year employee, at the time maybe 20 years, but someone that is very knowledgeable, very active, very highly regarded. So someone that would know the policy and how it works, whether or not he looks at his pay stub or whether or not he checks his annual leave balance, I think would be questions for a jury to determine. But I think it's also a question for the jury to determine as whether or not he intentionally tried to defraud by putting in the annual leave, or whether or not there was no, he actually never put in annual leave. I think that's a question for a jury to determine, and not a question for me. I believe that there is sufficient probable cause as to all of the elements. And so for that reason, count one, false pretenses, 1,000 to 20,000, will be bound over to the circuit court for further prosecution. Your bind over date's going to be the 13th of March. That's the date that the circuit court gets to file from the district court. You do not appear in court on that date, okay, sir? That's not a court date for you. Your next court date in circuit court, once they receive this file, they'll set a pretrial date, and that will be your next court date. Mr. Fickling will be made aware of that date, okay, sir?
Yes.
Okay. And so you'll remain in communication with your attorney. Bond was set at 5,000 personal recognizance. That's appropriately set. They'll continue at this time. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
Thank you. You're all set.
Thank you.
Please.
report saying he's still not confident, I think they can reform.
Oh, okay, so
We
we're
still have
sending out-
time, because I think. we
Let me
probably
call the
found
case.
Not confident, probably like 6-7 months ago, my guess.
On the record of the matter of the people of the state of Michigan versus Isaac Flamon, file number is 23-03158 FY. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. Flamont, Your Honor. Given the nature of this hearing, maybe wait, Mr. Flamont's present for
For the
being.
purposes of this.
Yep.
Thank you. Okay, today was the date that was set for a review. The court did receive an updated report from the Department of Health and Human Services Center for Forensic Psychiatry. It was dated February 21st, 2024. Council, you both received that.
Believe so.
Yeah, I have.
He's got that, got it.
Okay, and so the conclusion, the body and the conclusion of this update essentially indicates that the defendant still remains incompetent, and that the examiner believes that he can be restored or is expected to regain competency within the timeframe allotted by statute, if provided a structured inpatient hospital setting. And so that we know both from the other cases that we have has been a long and drawn out process because they don't have a lot of availability for the inpatient setting, but I guess he'll wait and see if he'll get that opportunity during the time frame allotted by statute. Is there any objection to the report or the conclusion of the report?
No, Your Honor.
I don't have any objection to it. The only thing that I don't know if there's anything we can do, but I'm concerned that I know this case is probably 5, 6, 7 months since we happened to it. He has yet to go to a hospital, get restored. I'm trying to see if there's any idea if we can, how much time that's gonna take before we can get him to the bed. I don't know if we have any power to do it. That's my concern.
I know we don't have any power to make any beds. And I also know that we have had other matters, or we have, not even had, we have other matters that are older than this one that have been waiting for a bed to become available. And some of them running up against the statutory timeframe. So it's just the nature of where we are right now. We're seeing a lot more individuals come back incompetent and needing that structured environment, and us not having facilities appropriate to house and provide the services needed. So we'll just set another update so that we can review, we can get an update and see. We'll also see if the forensic center can provide any time frame to the best that they can as to how long it's taking for people to get a bed.
24 months later, it's like Thursday, 18.
That depends on.
Yeah.
You got your question answered?
Well, I mean, I did in the sense that he just got in November, I think is when we found him that happened. So it's in the early.
Just, I have in December, I found him not confident. It's very early. It's been only 2 months since then. So I'm even surprised we got an update from forensic that quickly. But I appreciate them providing further updates. So we'll set it out. We'll do 90 days. And see if we can get an update.
Thank you, Ron.
Thank you.
If I, obviously, that's what I think we should be. Competency centers. Thanks, man. I'll see you tomorrow. If not, I'll see you next week.
Thank you.
Wait, we have that one. Oh, yeah, Myers.
I thought we already did this.
Myers is next. Well, then like.
I was like, I don't know that name.
So what?
This guy's the
Separate
website.
time.
It's been a long morning.
Okay, I know.
Yeah.
Do we have can we get a review date or is JIS done?
Constance said that.
Oh, okay.
Position.
Okay, the clerk's office will set the review date on that one, and then Hayward, Mr. Abbott's on that one. I hope he spoke to
I
us.
think,
see.
Paige hurried up.
So on the record, the matter of the people of the state of Michigan versus Patrick Andrew Hayward, file number 23-01973, council appearance.
Assistant Prosecutor Paige Petrowski on behalf.
Good afternoon, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Hayward, who is standing to my right.
Okay, Mr. Hayward, state what's the date set for hearing on probation violations that you were arraigned on back on the 19th of February. Are we having a hearing?
No, Your Honor.
Okay, so, Mr. Hayward, do you want to waive your hearing and plead guilty?
Yes, Your Honor.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, I do, Your Honor.
Thank you. You can put your hand down. Okay, and so the violations that you were arraigned on.
Yes, Your Honor.
Are not at the time. Give me a moment. Violations that you were arraigned on allege that you failed to pay fines and costs. There were no payments on your balance of $885.14. It alleges that you failed to enroll into testing at EverHealth on October 2nd, 2023. It alleges that you failed to provide or give proof of employment or disability, and that you failed to provide proof of enrollment of outpatient. It also alleges that you failed to report monthly to probation on October 19, 2023, November 16, 2023, December 18, 2023. It said defendant absconded from probation. So those are the allegations you're pleading guilty to.
Yes, Your Honor.
Anybody threatening you to get you to waive your right to a hearing?
No, Your Honor.
Anybody promising you anything if you plead guilty to these violations?
No, Your Honor.
Okay, and you're pleading guilty freely and voluntarily?
Yes, Your Honor.
As to failure to pay fines and costs, no payments made, balance of $885.14. How do you plead? As to the violations that you failed to enroll into testing at EverHealth back on October 2nd, 2023, as ordered by the court. How do you plead? As to the violation that you failed to provide proof of enrollment or outpatient treatment, how do you plead? Violation that you failed to provide proof of employment or disability, how do you plead? And the violation that you absconded from probation after not appearing to or reporting to probation in October, November, and December of 2023. How do you plead? On a factual basis, please.
Thank you, Your Honor. Mr. Hayward, is it true that on September 15th of 2023, you were sentenced by this court? And at that time, you were ordered to report to probation and continue reporting monthly? You were also ordered to pay fines and costs totaling $885.14. You were also ordered to enroll in testing at EverHealth by October 2nd, 2023. You were also ordered to provide proof or enrollment of outpatient services. And you were also ordered to provide proof of employment or disability status. And is it true that you did not do any of those things?
Yes.
And is it also true that you were ordered to report on October 19th, November 16th, and December 18th?
Yes.
And it's true that you did not report on those times? Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from you, Mr. Petrowski?
No, Your Honor.
Report satisfied with the factual basis. I'll accept your plea. I find your plea you may be voluntarily and intelligently. The recommendation of probation is to terminate probation and sentence or imposes a term of jail time. Since the defendant's overall acceptance of responsibility is poor, overall progress was poor, and the defendant has completed 0 terms of his probation, has taken no accountability for this case. Counsel, you can address the court.
Thank you, Your Honor. I did have a discussion with Mr. Hayward. I've also looked into this original file. Mr. Hayward was doing some treatment and programming at Bear River. It looks like there was possibly a disagreement with another patient there. And so he was removed from the programming there, and since then has admitted to me that he was struggling largely financially as well as with housing stability. And that is kind of largely what led to the downfall or decline of his participation in the probation programming and compliance here. He's expressed to me that he is very interested in trying to get treatment and working on his issues. And so if the court is inclined to terminate and enter a jail sentence here, he would be interested in and is already working on enrolling in the CATS program at the jail. And so I would ask the court to consider a term of jail at somewhere between 34 and 45 days. I say 34 because he's already served 26 days. That would bring him to a total of 60 days served on this and would allow him with that 34 to 45 days chance to meaningfully engage with the CATS program at the jail that he's already been working on, since his primary goal here is, as he said and I've stated, the trying to figure out the underlying issues here, any substance abuse issues, any mental health issues, while admitting that he's a person who struggles with housing stability and financial struggles. And it's going to be hard for him to ever comply completely with probation when those are his two primary struggles. So he wants to engage in whatever opportunities he can take advantage of at the jail, while also admitting responsibility and taking accountability for the kind of failures he did have here, which he admits he should have been reporting, should have been doing these things. He talked to me this morning about being afraid that if he did report to his probation officer when he wasn't paying for outpatient and testing, talking to his probation officer was just going to result in him getting arrested, which still should have been reporting. But I do kind of see where his fear is there. If he's not getting the program he needs if he's just getting arrested constantly, but he does want to take advantage of the program there. So I would ask the court to consider that time frame. Thank you.
Thank you. And did you want to make a statement? So,
Yes, there's no real excuse of why I didn't report. You know, it's me being, you know, a mess up. And that's really all it is, and I apologize for wasting the court's time. And so that's what do I got?
thank you. The court was aware at the time of the sentencing that the underlying issue as it relates in this particular case really stemmed from substance abuse.
Correct.
That's right.
And that this was not or would not have been the only time that you, Mr. Hayward, have engaged in the criminal justice system relative to substance abuse.
That's right.
And so we gave you a chance to demonstrate your ability to participate in oversight where you would have more of your liberties to do that. And that was not something that you were at the time capable of doing due to your circumstances, I suppose. But I appreciate you understanding and stating on the record that there's really no excuse to you not reporting, because that's free.
Absolutely.
And it's via Zoom.
I know.
We can't arrest you via Zoom.
No excuse. Like I said,
There's zero excuse for you at the bare minimum to have reported and have a conversation with your probation officer who's very well versed about resources and what could happen and what you could do as it relates to getting, because I ordered you also to get a substance abuse assessment.
Shame. That's really all I got. That's really what stopped me from doing it, is being ashamed.
I could imagine, but none of those things that will help you address, shame doesn't help you address the underlying issue. And if you're ever going to be rehabilitated to a functioning, upstanding member of this community, you're gonna have to address the underlying issue. We can't just operate in shame, because shame tends to make us hide from the issue. We want you to address the issue, get a grasp and get some tools that'll help you so that you can make better decisions about what you want to put in using your body. And then we want you to have some security. We want you to work if you're eligible to do so or able to do so. We want you to have a home, a roof over your head. We don't need you to still be living with your mom. That's not what the goal or what your goal should be. Nonetheless, I think it is an appropriate recommendation from your probation officer to terminate the probation, because I don't think you're a good candidate for it. So probation will be terminated. I'm going to sentence you to 93 days in Ingham County Jail. I will give you credit for time served. You'll be ordered to continue engaging with CAPS programming, and you need to have a updated substance abuse assessment to the extent that you have not had one since I remanded you. And I will allow you to be released to inpatient treatment if that's an option or something that becomes available to you. You will not get any GPS tether release outside of that.
Thank you, John. I greatly appreciate that. Really. Thank you.
Do you have any questions?
Just thank you.
Oh, no worries. You're welcome. Any additional matters for the record, council?
No, Your Honor, thank you.
Thank you. You're all
And
set.
can I say, I like your hair, by the way.
Thank you.
Thank you. I see last time I see it was all big. I like it like how it is. Thank you.
Thank you.
Yeah, yeah. Yeah, thank you. Thank you again.
It's good to hear, finally appear in front of you.
I
never
know,
have
you're
before.
never in here at all.
I was joking about it yesterday in the office, and then Mr. Lee sent out the email asking, because he's doing arraignment today. I'm like, you know what? I was just talking about it. Time to put my hand up.
Thank you.
Have a good day.
Have
Your
a good
Honor.
one.
See.
Okay, so we are ready on Mr. Rhodes.
Yes.
Okay, on the record in the matter of the people of the state of Michigan versus David Rhodes, file number is 24-00234FY, council appeal.
Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the Attorney of Record Aaron Robinson for the defendant David Rhodes, who is present standing to my right.
Okay, Mr. Rhodes, you're still doing okay today?
Yes, I'm doing fine.
Okay, very good. So today is the date set for a preliminary examination, one count of carrying concealed. We're ready to proceed with the exam.
Yes, people are ready. Kristen.
That's my understanding. The defense is ready to proceed with the exam.
Okay, we can call witnesses unless there's a preliminary matter we need to address.
There's nothing in front of people.
None for defense.
Okay, call your witnesses.
Thank you. The people will call Trooper Andrew Golden. Oh, no, over here.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat. Let's see. And can you state your first and last name and spell both?
First name Andrew, last name Golden, first name Andrew, last name Golden.
Okay, counsel, you can proceed.
Your Honor, good afternoon, Trooper Golden. How are you doing?
Good afternoon. Good, thanks.
Where do you work?
I'm currently employed with the Michigan State Police out of the Lansing Post.
And what is your title?
Trooper.
And what do you do as part of your duties under that title?
I respond to 911 calls for service and initiate traffic stops violations.
Were you working in that capacity on November 23rd, 2023?
Yes,
Were you working on Cedar Street near Edgewood?
yes,
Did you observe a vehicle stop at that light when you were at Cedar Street?
yes.
Can you describe what you observed about that vehicle?
Yes, I was stopped at a traffic light on Cedar facing northbound near Edgewood. I observed a white Challenger stopped at a red light facing southbound near Edgewood, southbound Cedar on Edgewood.
Was there anything notable about that vehicle to you?
There was a defective passenger side headlight, so the passenger side headlight was completely out.
What did you do after you noticed that the headlight was out?
So I observed the vehicle move over into the right lane and proceed to travel west on Edgewood Boulevard near Cedar. After I observed the violation of the defective passenger side headlight, I proceeded to travel westbound Edgewood Boulevard behind the vehicle to get behind the vehicle to initiate a traffic stop.
And did you successfully initiate a traffic stop?
Yes,
Where did you end up making contact with the driver of the vehicle?
the actual traffic stop was initiated in the Target parking lot. It's on the south side of Edgewood, just west of Cedar a little bit.
Okay, is that in the city of Lansing,
Yes,
Hingham County,
yes,
state of Michigan?
yes,
So you initiated the traffic stop in the Target parking
yes.
lot. And were you working by yourself that night?
I had a partner, Trooper Luke Schaefer.
So When you initiated the traffic stop, and did you speak with the driver of the vehicle?
Yes, I initiated contact on the driver's side of the vehicle.
Who did you speak with?
Mr. David Rowe.
Did you see his face?
Yes,
Would you recognize him if you saw him today?
yes,
Is he present in the courtroom?
yes.
Can you describe where he's located in an article of his clothing?
Yes, he is sitting to the right side of his attorney, a black Adidas jacket and a light blue dress shirt underneath.
Let the record reflect that he is the witness has identified the defendant.
Any objection to identification?
No, Your Honor.
Identification is noted.
So when you met with Mr. Rhodes, did you ask him any questions?
Yes,
Do you remember what those questions were?
yes, I asked where he was coming from. He advised he's coming from a friend's house. Advised he's going back to a friend's house. I asked him why he pulled into the Target parking lot. I do not recall verbatim what he said. I believe it was just hanging out or just gonna be hanging out in the parking lot for a little bit.
What time was this? Or around what time?
Approximately 0300 hours, I believe.
And in non-military time, is that 3 o'clock in the
3
morning?
a.m.
Did you ask him about anything that might be in the vehicle?
Yes, on every traffic stop, I always ask about narcotics. I asked specifically any in the vehicle. He emphatically stated no. I asked if there's any cocaine. Again, emphatically stated no. Any heroin, emphatically stated no. And then I asked if there were any guns in the car. The tone in his voice dropped, and he was looking down. He stated no, sir.
So you noticed, so there was something different about his disposition?
Yes, change in behavior.
So what did you do after you noticed that change in behavior with this response?
I asked him directly where the gun was at in the car. He then was adamant that there was not a gun in the car. I then observed his chest start to rise and fall more rapidly compared to that initial interaction with him, with the other questions I was asking.
Did you ask him, did you follow up on those questions, on that question?
Yes, I asked him just to be honest about it. He did then admit he had a gun. And then I can't remember if he pointed or he just verbally stated where it was at in the driver's side.
Okay. It was in, so he said that the gun was, or indicated that the gun was in the driver's side door.
Yes,
Where were you positioned when you were having this conversation?
I was directly at the passenger or the driver's side door.
Were you able to look inside his window from where you were standing?
Yes, I peeked my head through the window and was able to observe the pistol in the sleeve that's on the driver's side door.
Did you ask him about that pistol?
Yes, he admitted it was his pistol, requested him to exit the vehicle, denied having a concealed pistol license.
And when you observed the pistol, are you able to describe it at all?
Yes, so the black Smith & Wesson 40 caliber. We rendered the pistol safe. There was 1 round in the chamber and 13 rounds in the mag, or 12 rounds in the mag. So 13 in total.
And were there any other passengers in the car?
No,
No further questions.
Cross-examination.
Thank you, Your Honor. Good afternoon, Trooper Golden.
good afternoon.
All right, so you testified that you recovered a gun from the driver's side door of the defendant's car.
Yes,
All right, and did you check that weapon in lien?
yes,
All right, and did it come back registered to the defendant?
yes,
Okay. But it was your testimony that he did not have in the lien system a carrying a concealed permit license?
yes.
Now, did you initiate any lights and sirens before entering the Target parking lot?
Negative. I believe the lights were activated as we were in the parking lot.
Okay, and when you pulled in the parking lot, was the defendant's car already stationary?
I believe so. It may have been slow rolling into a parking spot as I was hitting the lights, but I cannot remember specifically.
Right, and were there any other cars in the parking lot at that time?
No.
And you also ran the defendant's name and information in the law enforcement information network, correct?
Correct.
All right, and did it state that that the defendant had no criminal history?
Yes, you had a clear history.
Okay, all right, no further questions, Your Honor.
No, Your Honor.
May this witness be excused?
Yes, he might.
Thank you, Trooper Golden.
Thank you.
Do you need me to sign your subpoena?
No.
Any additional witnesses?
No, Your Honor.
Okay, is it the defense calling any witnesses?
Just one moment, Your Honor. So, Your Honor, I have word your, I've had a discussion with my client about his rights, and I would leave it to him at this time whether he would like to testify or not.
Okay, you would like to testify today?
No, I wouldn't.
Okay, okay. Proceed to argue.
Thank you, Your Honor. Defendant is charged with carrying a concealed weapon, pistol in a vehicle. The testimony that we heard today from Trooper Golden stated that on November 23rd, 2023, in the city of Lansing, County of Ingham, state of Michigan, he initiated a traffic stop on Mr. Rhodes due to a defective headlight. During the course of that traffic stop, after being asked whether he had any drugs or weapons in the vehicle, Mr. Rhodes himself admitted that there was in fact a pistol in the vehicle and indicated where the pistol would be located. Then Trooper Golden was able to look in the vehicle and see and clearly see the weapon within the vehicle. From this testimony, it is especially to a probable cause standard. There's sufficient evidence that one, the pistol was in a vehicle that the defendant was in. Second, that the defendant knew that the pistol was there, given that he told Trooper Golden where the pistol was located and that the pistol was there. And third, that the defendant took part in carrying or keeping the pistol in the vehicle. The fact that the defendant was the only person in the vehicle and that the pistol wasn't registered to him and that he was able to knowingly state that he did not have a CPL for that weapon all speak to the fact that to a probable cause standard, these elements have been proven. And people would ask the court bind this case over to the circuit court as charged.
Mr.
Thank you, Your Honor. We ask the court to consider the elements of the offense that the state has the burden to prove by probable cause that the defendant, Mr. Rhodes, did carry a dangerous weapon, that being a pistol, otherwise in a vehicle operated or occupied by him, and that being a Dodge Challenger in the city of Lansing on or about November 23rd of 2023. And obviously, we have one witness, the trooper did testify. So, Your Honor, with that, we would ask the court to consider the testimony and not to bind over this. Thank you.
Okay, today was the date set for preliminary examination. The burden is on the prosecution to establish that they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. This is not a trial. This is not weigh your guilt beyond a reasonable doubt. That's a much larger burden that if this matter were to go to trial, they'd have to face over at the circuit court. This is just more than mere suspicion that a crime was committed. And I only have one witness to weigh that evidence by, and I don't have anything currently here to cause me to believe that there was some credibility issue as to what the witness testified to. So the witness being Trooper Andrew Golden testified that on or about November 23rd, 2023, at the area of Cedar and Edgewood, that he made contact with a vehicle, or he observed a vehicle, I should say, that being a white Challenger with a defective headlight, that he observed the vehicle travel westbound on Edgewood, that he followed that vehicle, he initiated a traffic stop in the parking lot for the Target on Edgewood. I believe that's 500 East Edgewood, but I could be wrong, but that's City of Lansing, Ingham County, State of Michigan, according to the testimony of the witness, that he made contact with the driver, who he identified in court today as being the defendant, David Rhodes. He stated he asked specifically if there were any narcotics in the vehicle. He said that it's typical for him to ask. He even went through like what he asked, which I thought was a little different. He asked if there was heroin, any meth, any cocaine. What if there was other narcotics? I don't know. I guess he only concerned himself with those three. And to which he received a negative response. He stated he asked about whether or not there were any guns, and he testified that he observed the defendant's tone drop and that he appeared to look down, and that there was a change in his behavior, and then that there was his chest started to rise and fall more erratically. I'm assuming he's sharing that to testify that that those were signs that maybe he didn't believe what the defendant was saying or the subject was saying. It could be that, or it could be he's fearful because he's being stopped at 3 o'clock in the morning by an officer. I don't know. We'll leave that for a jury to determine. Nonetheless, he testified that after multiple questions to the subject about whether or not there was a firearm and where it can be located, the defendant admitted there being a firearm in the vehicle and pointed to where it was located. And the officer said he peeked his head inside and was able to observe the pistol. He did run a lean check and found the pistol to be registered to the defendant. There was no valid CPL at the time, and one round in the chamber he found in the pistol. To prove it at trial, the people would need to prove each element beyond a reasonable doubt. First, that the pistol was in a vehicle that the defendant was in. Well, we heard testimony that Mr. Rhodes was driving the white Challenger when he was stopped. Second, that the defendant knew that the pistol was there. Officers testified that after some rounds of questioning, that the defendant testified or admitted, I should say, that there was a pistol and pointed to where the pistol was. And third, that the defendant took part in carrying or keeping the pistol in the vehicle. I didn't have or hear any testimony about this actually being the defendant's vehicle, but there was obviously testimony about the pistol being registered to the defendant. So there is sufficient probable cause on each element. So the count one will be bound over to the circuit court for a bind over date of March 13th. That's the date the circuit court gets the file from the district court. You do not need to appear in court on that date, okay?
Okay.
Your next court date, pending any motions filed by your attorney, will be a pretrial. And that's gonna be set after the circuit court gets the file, okay? So in contact with Ms. Donnelly, also advising if your address for whatever reason changes between now and then. I think we have an address. You don't have a local address, is that correct?
Correct.
Okay. Okay, bond was set at 1,000 personal recognizance that will continue. Any additional matters for the record?
Nothing for the people, Your Honor.
Nothing for defense.
You're all set, sir.